deal with part 2 of my take, and I promised you that I'll deliver part 2 of my take, which I delivered last week, titled Police Lawful Duty, Your Rights When Arrested. Police Lawful Duty, Your Rights When Arrested. I'll do a summary so you can read my take on my Joy Online. So last Saturday, I introduced you to and required you to insist on your what I refer to as the Miranda rights when you are arrested. You ought to be told about the fact that you are being arrested and be told in a language that you understand immediately upon being arrested, restricted, or detained, the reason for your arrest. And finally, you ought to be told of your right to a lawyer, not any lawyer, but a lawyer of your own choice. And you don't have to incriminate yourself from that point, because anything you say upon that from that moment can be used against you in court. And that's what we mean by the Miranda rights when you are arrested, and they ought to make that clearly to you immediately. Now, on the question of the second segment of my take, I said I'll deal with the question of bail, and said that bail is not automatic, as was being claimed that the police were under a duty to grant bail within the 48 hours of the arrest of a person. No, they are not. That is not law. You don't find it anywhere. The law's provision in Article 14 of the Constitution is that they have a right to hold you for that period. And if they intend to continue to hold you, they can only take you to court within the 48 hours. So if they intend to take you to court on the 48th hour, they have no obligation, not at all, to grant you bail within the period. In fact, the purpose sometimes is that because they are doing investigations and they are not completed, they want to use that period to do certain things. And that if you are released, you may compromise the processes of investigations. But the constitutional position is that because all persons are supposed to be, accused persons are supposed to be presumed innocent until they have been proven guilty by a court, or they themselves have admitted so, they ought to be deserving of the right of a bail pending their trial. Now, also, the Constitution requires that you ought to be afforded all facilities and reasonable time so that you can do what? Put forward your defense. On that reason, on that basis, it is important that if bail is available, you ought to be granted one. In fact, when you are not granted bail by the police within that period, you can't question it in any court of law. I was surprised, however, when the Constitution Review Commission set up in 2010 recommended a reduction of the pretrial detention period from 48 to 24 hours. Government issued a white paper rejecting that recommendation because we know the police have often abused it. I mean, unprofessional police persons have often abused it. They have used it to, as they say, for shaggy reasons, to keep people in, use it to, as it were, become debt collectors for their girlfriends and friends, and so on and so forth. So read my take about that. In fact, when you are not granted bail, the point where you can actually question the reason for not being granted bail is when a court refuses to grant you bail, a lower court refuses to grant you bail. Then you can go to a higher court and challenge the reason for not granting you bail, because the law says that bail should not be used as punishment. And in fact, the terms and the amounts that are supposed to be fixed, the courts are not supposed to fix them in such a way that they serve as a punishment. The law says they ought not be excessive. And for as long as you are not a flight risk, for as long as you are not someone that is feared to compromise the investigation process and all of that, the court ought to grant you bail. So if they don't, you have the right to go to a federal court. And as you see, we often do as lawyers, we go to a federal court and the court grants bail eventually. So bail is not automatic. It's a discretionary relief, even in court. And a discretionary relief though it is, the court is supposed to exercise that discretion judicially. The processes laid down by law ought to be followed. And I ought to say finally that there used to be a law that disallowed bail for certain offenses: murder, terrorism, narcotic offenses, defilement, rape, and so on, treason. However, thanks to Martin Pebu, in 2016, he got the Supreme Court to strike that down, so there's no more non-bailable offenses. However, it is a matter of the discretion of a court to grant bail or not to grant bail. Thank you very much.